jurisdiction. It was in Book 3, Chapter 7 commentaries. Glanville's writings confirm that Henry II's regime issued writ of prohibitions to block church courts from hearing cases that involved lay property, such as the controversy with Thomas Becket. Henry II, well, hell, that's the guy that started the goddamn grand jury back in what, 1860 fucking 8? 1168? 1172? Way back in the 1100s. 1100s. So for 800 fucking years, we've had the grand jury. The Assize of Clarendon. Henry VIII's courts, particularly the King's Bench, issued prohibitions, writs of prohibitions to prevent ecclesiastical courts from interfering in annulment proceedings related to Henry's marriage to Catherine of Aragon, aligning with the Act of Supremacy, 1534. 1534. So this is all about the writ of prohibitions. What do you know about the writ of prohibitions? You're allowed to do a writ of prohibition. The All Writs Act, 28 U.S.C. Section 1651, governs mandamus, prohibition. What other writs are there? The writs of crackers. In Darcy v. Allen, the case of monopolies, Queen Elizabeth I had authorized Edward Darcy, groom of the chamber, a state-sanctioned monopoly over the production of playing cards. Elizabeth I wanted to regulate playing cards because she believed that they were a problem for the English people. Thomas Allen was producing playing cards, and Darcy sued Allen for infringing on his monopoly. Hey, wait a second. The Queen said, me, Edward Darcy, gets to produce playing cards. But Thomas Allen knows how to do it. He's been doing it for years, and he's going to keep on doing it. Hey, that's not nice. I'm going to sue him. The Queen says, me, Edward Darcy, gets to... How dare you, Thomas Allen? Darcy sued Allen for infringing on his monopoly. A writ of prohibition was issued by the Queen's Bench. There's a King's Bench, and then there's a Queen's Bench as well. A writ of prohibition was issued by the Queen's Bench to prohibit an ecclesiastical court from interfering in the commercial dispute over a patent-protected common law jurisdiction over property rights. The judgment of the Queen's Bench was that monopolies were inherently illegal because they produced subpar goods and caused idleness in tradesmen. Darcy himself didn't know how to produce playing cards. In Bagg's case, the guy that had the fucking monopoly didn't even know how to make the goddamn fucking playing cards. In Bagg's case, town official James Bagg was removed from local court by a local corporation without a hearing because James Bagg had spoken mean words about the mayor. The King's Bench, under Edward Coke's influence, issued a writ of prohibition alongside a mandamus to prevent the corporation from proceeding without due process. In Dr. Bonham's case, Chief Justice Edward Coke issued a writ of prohibition to prevent the Royal College of Physicians from imprisoning Dr. Thomas Bonham for practicing medicine without their license. Edward Coke ruled that the college exceeded his jurisdiction. The college exceeded its jurisdiction as its actions violated common law principles, common right and reason, and the right to liberty. The Royal College had acted as both prosecutor and judge, violating the principle of nemo judex in causa sua. This case is notable for Coke's assertion that common law could invalidate acts of Parliament defending individual rights through prohibition. Nemo judex in causa sua. Well, that principle is what? You can't be both the prosecutor and the judge. That's the principle. Wait, you're the goddamn prosecutor and the judge? You can't be a judge in your own cause, in your own case. Yeah, you can't be a judge in your own case. That's what Nemo Judex calls a sua is. Right? Sua sponte. Sua sponte says that on their own initiative. So this case is notable for Koch's assertion that common law could invalidate acts of parliament. That is fucking fantastic. So the common law could just invalidate acts of parliament. So the legislature, the Congress, the parliament, all these motherfuckers get together, they pass a law, and then some asshole's like, well, according to the common law of fucking 1233, you're not allowed to do that. In the 1607 case of Prohibitions, Chief Justice Edward Koch issued a writ of prohibition against King James I's assertion of his divine right of kings to claim the power to judge cases. King James I had judged a controversy over land and had imposed a sentence. James said it was treason to assert an authority above the king, that only God was above a king. Edward Koch, quoting Bracton, retorted that the king is under both God and law. Koch wrote that law was the golden met wand. The king's natural reason wasn't good enough to judge of case. Wasn't good enough to judge of the case, and since Koch had artificial reason and judgment of law, which required long study and experience, an independent judiciary was the best place for the adjudication of cases. So the case of Prohibitions. This is a writ of prohibition against King James I's assertion of his divine right of kings claim to the power to judge cases. The king wanted to fucking judge the goddamn cases. The king wanted to judge the cases and take that power away from the judiciary. And so a writ of prohibition was used to stop the fucking king. It's not just used for lower courts, but it's also used for the fucking goddamn executive. So a few patterns with the writ of prohibition. It's used to prohibit something, and it's typically a lower court's overreach, and sometimes it's preventing an action in the future. Other times it's stopping a court decision that's already been decided. The Magna Carta. The Magna Carta isn't a recipe for medieval meatloaf. You sons of bitches. The Magna Carta isn't a recipe for medieval meatloaf. Come on, stick the landing. The Magna Carta isn't a recipe for medieval meatloaf. You think it's a recipe for medieval meatloaf? Is that what you think Magna Carta is? The wicked clings on to Hurtado, 1884, a relic of the Whig Court and a nightmare of any true blue textualist. Oh, he loves our Hurtado, with their shriveled and arachnoid and spindly and cadaverous hands. Like it's their security blanket. Instead of upholding the Bill of Rights, the wicked devour the judge, the jury, and the executioner's power by the fiat scribblings of a totalitarian DA. The community-backed grand jury indicts by truth and evidence and probable cause, and yet the wicked cower underneath fictions and lies and false accusations dressed up as information from the lonely and ravenous and craven. We might as well allow the fox and the wolf to guard the hen house and the sheepyard. John Armour Bingham's ghost is shouting, my fellow Americans, protect your privileges and immunities. You only get the freedoms you have the intelligence to want and the courage to take. The wicked prefer their injustice served with the side of tyranny, so they keep John Armour Bingham's spirit stifled inside a lamp, just like Aladdin. Or no, just like the genie from Aladdin. Riff-raff, street rat, I don't buy that. Only they'd look closer, would they see a poor boy? No, sirree. They'd find out there's so much more to me. A whole new world, a brand new place I never knew.